what are the costs associated with converting leases?
Okay, so you'll have two different individuals. The first one is the person who is converting. You have a lease. When you are taking up or when you are purchasing the lease, you had to pay to the government stamp duty. You had to pay the advocate's fees along with the purchase price. Now, when you are going ahead to convert, the Act as it is allows for those who are converting, that is, you'd already bought, you'd already paid stamp duty, and you now own the home, to be exempt from paying stamp duty afresh, because the interests in that property is not shifting from one individual to the next. You'll note that when you're shifting an interest from one individual to the next, the government levies a tax. That tax is what we call stamp duty. Here you're simply converting your title from one form to another, but the interest remains with you. So the Act exempts payment of stamp duty. However, there are other costs that you look at as a proprietor or as a homeowner. For example, the legal costs, those are not exempt. You'll have to pay your lawyer to do the work. You will have the surveyor's costs. Again, you may have to pay a surveyor who you contract. So yeah, the Act simply exempts one part. The rest, they are still there for those who are converting property from the old lease to the new lease, to the new leasehold interest. Those are the main costs that you will be looking at the onset. You'll also have those who are buying properties. Now, when you're buying properties and this process is being done from the get-go, then it is expected that once you buy the property and sign the sale agreement, you will pay the purchase price. Other than the purchase price, there are legal costs to preparation of this documentation. Those are costs that you will incur. And because at the point of purchase, the interest is moving from the developer to you, or from one homeowner who has bought and has their lease registered to another, there's a shift in interests. Therefore, the stamp duty or the levy from the government then applies. So you'll have stamp duty payable on such a transaction. So those are the costs generally that you are looking at the onset when you are converting your property to sectional properties or buying a property under the Sectional Properties Act. Of course, for those who are buying, the developer may decide to have the surveyor's costs included, or you may have to incur that surveyor's costs, but ultimately that's a cost that you that will most likely accrue to you at the point of purchase if you're buying under the sectional properties. So yeah, generally those are the costs that we are looking at.
Okay, and then what happens to rates and rent payment under this new regime? Like, how do you go about it? As an individual, you're now going to be responsible for that on your own, because before it's like it's the management company that would handle it as one.
So as it is currently, you'll have your specific title, that is the sectional title, for which you're expected to pay land rent and rates. So what used to happen initially was you'll have one title, and then if you have 10 apartments, each apartment would have a lease instrument or a lease interest registered against the main title. But the rent payable is on the land, not on the different houses. That was what was there, or that is what those who have long-term leases will experience, so that you, all 10 of you, will contribute towards payment of land rent and rates for that particular property. Under the sectional properties, it's expected that each homeowner having a title should pay land rent and rates for their specific units. So the Act comes in to help government efficiently collect tax, so to say, and also you'll have the homeowners benefiting in the sense that initially if one of your neighbors, for example, failed to contribute towards payment of rents and rates, That's a requirement at the point of transferring interests, that rents and rates have been cleared, or if you need to take a loan on your property, the bank may require rents and rates clearances, because that in the long term has an effect of having the property encumbered, so to say, so that you can't deal with the property without having cleared these rates. So under the new act, you'll have each homeowner being responsible for paying their own land rates, and that way they then remove themselves from having to convince everyone else, hey, let's pay so that I can transact, or hey, let's pay because we will incur some penalties if we don't. Each homeowner is responsible for paying their own land rent and rates, as opposed to the scenario as it was initially, where the management company, as the holder of the leasehold interest, was responsible for making payments of land rents and land rates.
Okay, and maybe to take you back a little bit, you can just distinguish between what rates are and rent is, for those who may not be familiar.
Now, land rates and land rents, these are different charges that are payable to the government. Now, when you own a property and it's on lease, you will then find that the services that you will receive, say water, cleaning of that particular area, or maintenance of that particular area, and some of these services are conducted by the county government. Now, for those services that are conducted by the county government, you'll then pay a service or a charge to the county government. This charge that you pay to the county government is what we call rates, land rates. They are payable to the county for services that the county is expected to provide. If it's drainage, if it's generally keeping the property, the surrounding areas in a good condition, so to speak, the public spaces, you pay rates for that. As a leasehold owner, or as an owner of a leasehold interest, you've leased out this property from someone. That's the government of Kenya. So from the national government, the government will expect that you pay rent on that lease. So the annual rent is usually paid annually, and that annual rent is often indicated on the title, the mother title. Of course, it's revisable. So the government might revise this rent either upwards, I'm not sure if it can do so downwards, or downwards in the event that there is that need. So that rent is the fee that you pay to the lessor, that's the government. So that's the distinction between land rates and land rent. It pertains to what are you paying for. Number two, who are you paying to? So if you are paying for the lease that you hold, and you'd be paying to the lessor, you pay to the national government. Whereas if you're paying for services such as ensuring your sewer line doesn't burst every time there is rain, you'd pay that to your county, and that's the land rates. Sorry. Okay. Yeah, so that's a distinction.
Okay, thanks. Now, as we conclude, what does a sectional title look like? Because for apartment units and other sectional units, this leasehold instrument, people sometimes find it hard to believe that it doesn't look like a title, because what people have in their mind about a title is this document with, the seal, the red seal, and what they get is really a large document that doesn't look anything like what they expected. So what does a sectional title look like?
Okay, so a sectional title would take the form of a title deed. So that looking at the document that you're presented with, it's a title deed that has several leaflets, about 4 pages. And on the first page, you'd be able to see that this is a sectional title. It is indicated on the title, the law under which this title is given, that is the Sectional Properties Act. It would have the proprietor's name indicated. Say this title belongs to James Gitau of ID number this, PO box number this, And the sectional title will also indicate the share of the common property that you own. So that if we are 10 of us, it would indicate that I own 1 share out of 10 in the common property or common area that we own. Now the title will also indicate the interest that you're getting. Is it a leasehold interest or is it a freehold interest? A leasehold interest is an interest where you've leased this property from the government for a long period of time. That's what we call a long-term lease. So mostly it's 99 years, or what is provided for in the law is about a 99-year lease. So for these long-term leases, you should be able to see when the lease was issued, and from there you can compute what period of time is left before expiry of this lease. So that's a leasehold interest. A freehold interest is an interest where you are the absolute owner of the property. The government didn't lease it out to you. Once you bought the property, it was yours wholly. So you're an absolute owner. So for a sectional title, it will be, that title would say whether it's a leasehold interest or a freehold interest that you hold in the property. You'll also have a section that tells you of the encumbrances. Now, encumbrances are interests that third parties may have on your property. For example, if a bank takes up that property as collateral, they will register an interest in the form of a charge against your particular property. That should appear on the sectional title. So if the developer had taken up a charge in order to buy a title security so as to buy this property, and it's not yet fully discharged, then you'll have an interest of the bank that gave that collateral moving on to each and every title that is issued. You'll also have encumbrances such as restrictions. What can you not do on this particular property? These are issued by either the registrar or the title. Once it's processed, it can have certain things that you're not supposed to do based on the zoning laws that are there in place. You'll also have, if there is a court order that is issued affecting that property under the encumbrance section, you'd see it as an inhibition preventing any dealings with that property. And finally, you may have a caution. This is an interest registered by either the proprietor or third party, informing the public or anyone who comes into contact with that title that there is an issue with this title that we are dealing with, or there is an interest in this title that is yet to be dispensed with. So that would come in under the encumbrance section, and that's pretty much what you'd be able to see when you inspect a title that is a sectional title. So it would have the seal that generally people expect it to have, what they tend to look out for, and a sectional title at the top. This is distinguished from what people have currently. What you have is a lease instrument. Now, the scenario as it is the developer comes in, puts up apartments, and on these apartments, there's only one title. So they then come and approach you and tell you, I will sell you this particular house, and I have a lease for 99 years and want to sell. That's the interest that they're essentially selling to you. Now, to do that, the developer would incorporate a management company, the company that manages that particular property. And you'll have an agreement that has the management company in it, the developer, and yourself, the person who is purchasing, so that that agreement as between you two is registered as your leasehold interests in the property. Now it is registered against the main title, so that if you inspect the main title, you will see James bought apartment number this on this particular day, on such and such a day. You will have that information being entered on the main title, and that then is your interest in the title. That's the direct connection between you and the title. You have a physical manifestation of that in the form of a lease instrument. Now, The main title, we can't split it into 10. That would be impossible. And number 2, the land laws envisage that each property should have just one title. You can't have multiple titles being replicated describing the same property. So the management, that's where the management company comes in. It's assumed that once all the properties have been sold, the developer would transfer the ability to renew the lease to the management company and issue you a share in the management company, one share in the management company. That way you have a say in the company that controls the main title or where your property is. So in such an arrangement, you'd have a lease instrument that's in the form of an agreement. It more or less often resembles, it's in the form of a booklet, and that interest is registered against the main title. So that if you inspect the main title, you will be able to see that this person has an interest in this particular unit. So that is what has been there for the longest period of time, and that's distinguished from a sectional title, which simply describes your property, what you own. It should also describe your property, so that from looking at the title, they can be able to tell which unit it is, which floor it's on, and having that along with the sectional plan, you should be able to get a clear picture of what the property looks like. So those are the distinctions between what a sectional title looks like and what a lease instrument looks like, and the laws under which these two are formed.
Okay.
Yes.
Okay. Now we can go back a little bit to the corporation and the management company. What does the corporation do that the management company wasn't doing, and what's the difference?
Okay. So as it is currently, or as it were, you'd have a management company being incorporated to manage all of these properties. The management company is incorporated under the Companies Act. Now it's a company that you will have certain requirements that are imposed by the Act. For example, be it filing returns, be it the structure of how the company looks like, and more importantly, the Companies Act prescribes a particular number of members of a company. For it, you'll have different companies: private limited liability companies, public companies. Now, public companies are those companies that will be able to trade their shares publicly, and you can be able to buy shares into those companies. The prescribed number, maximum for a private company, is 50. So if I have a developer who has 150 homes, you realize that these homeowners, each one of them, if they are getting a share and they are members of this company, once they surpass 50, there's an obligation for this company to be converted into a public company, purely for purposes of complying with the law. It's a public company that members of the public have no interest in or won't be able to come in and deal with, and that presents certain challenges and restrictions of their own. And the corporation, under the Sectional Properties Act, is a different creature altogether. This is a corporation that's established by the Sectional Properties Act, and the Sectional Properties Act governs what it looks like, what membership is, its registration, and number 2, it also the Act also provides for the corporation having bylaws, and those bylaws are what would guide how the corporation works, from how it's run, if there is a fund, or rather once there is a fund that's established, what should be done with that money. It also provides for leadership of that corporation, who comes in to govern that corporation. It prescribes a term of 1 year. So you'd have a normal company or conventional company where you'll have directors that are there, and some of these aspects, they are not really properly, or the regulation that's there wouldn't be customized for a company that is managing property that is owned by 10 or so homeowners. So the corporation is customized to work for the homeowners. It's not the company, it's not the holder of the leasehold interests. Now you have your various titles that you own, and that title also extends to what portion of the common property do you own. So from a regulatory standpoint, those are really the differences between a corporation and a management company. And also when you look at it as in terms of what are the practicalities, you then realize that if we are to have any public companies coming in as a result of owning homes, it may not be that ideal. The corporation then becomes the vehicle that is properly suited for purposes of home ownership. Yes.
Okay, thank you. Now, as we wrap up, is there anything else that Kenyans should know in terms of if they want to own a home or any kind of unit about the Sectional Properties Act?
Yes, I think most importantly is that the Act provides for a compliance period. So the Act came into effect in December of 2020. That was 28th December 2020. And homeowners or owners of units have to ensure that they comply within a particular period. The Act provided for a 2-year compliance period. Now that 2 years will be lapsing this year. That is 2022, December 28th, if I'm to be very, very specific. But that's up to government to give guidelines on compliance. Why is compliance important? Because if you fail to comply with the requirements of the Sectional Properties Act, that attracts a liability both at an individual level and at the company level, where you'd have people looking at penalties of up to 250,000 to a maximum of 20 million shillings for failing to comply with the provisions of the Sectional Properties Act. So it's mandatory really for those who have long-term leases at the end of the day to ensure that they comply with the provisions of the Sectional Properties Act. And for homeowners who are buying property, it's important to raise that question. Are we compliant? When you're selling me this property, are you registering it under the Sectional Properties Act? If not, when do you intend to comply? So as to ensure that in future you don't have back and forths, and when the government decides to enforce, which most Kenyans end up being last minute people, you don't come and you are scrabbling to ensure that you comply. So it's important to have in mind that the Act, when it came into effect, had a compliance period. And that compliance period, as far as we are concerned in legal practice, hasn't really changed. There's a 2-year compliance period that was given, and it's expected that people will work to ensure that they comply. So as a homeowner, that's one of the things, or the most important thing that you may want to look at when you're buying property under the Sectional Properties. It's also important to check the bylaws. What do they say? Because they will affect you individually. When you are renting out this property, for example, if you're buying for commercial use, the law and also the bylaws as would be structured have certain expectations for the tenants. That the landlord will notify the corporation that there is a tenant, that the tenant will also adhere to these bylaws, so they need to know of these bylaws. And you need to skim through and see what interests do they protect on your part and which interests are exposed. Of course, this would need consulting an advocate so that they can go through this with you and tell you, look out for this, this and that. So yeah, you'd have to look at that, and also the agreement for sale. Really, when you're buying a property, check through to see what does it say about the property, whether it's sold under sectional properties or in what nature is it sold. If it's silent, you want to have a discussion with the developer and find out so what happens to this particular issue. All of this, of course, is geared towards ensuring compliance. You fail to comply, then there are very real consequences for you as a homeowner. Similarly, for banking institutions that give out loans, they have titles that are in their possession that they have as collateral. It's expected that these titles too should be in compliance with the Sectional Properties Act. So as a financial institution, you can't just sit on the title and expect everything will be okay. At the end of the day, you have to ensure that you have an engagement with the customers and the developers or management companies to ensure that these titles comply with the Sectional Properties Act. Another adverse effect of failing to comply would be the registrar putting a restriction on dealings in your property. What this would potentially mean is you may be prevented from selling that property, charging that property, discharging that property if you finished paying off your collateral, up until the point where you ensure compliance. So the real big issue that Kenyans should have in mind is ensure you comply. It's a requirement of the law.
Okay, thank you very much. And as we wrap up, I think it's important to note that all this information is for educational purposes, and if somebody is keen on converting their title or knowing more, it's important to consult an advocate on that. Thank you so much. We have been speaking to James Gitau, who is an advocate with Simba and Simba Advocates, on all things Sectional Properties Act. I hope that you have gained some knowledge and understood more about the Sectional Properties Act. And until next time, I have been your host, Claire Munde, and this has been the Property Simplified show. Have a good one.